Hi, I'm Tom Fitton, President of Judicial Watch. Welcome to our weekly update about Judicial Watch's activities here on Facebook Live. I wasn't here on Friday, so there's a lot to catch up on. New Clinton emails to discuss. We had a major deposition today in the Clinton email matter. A new announcement on on election monitoring or poll watching by Judicial Watch. So a lot to talk about. Let's talk about the news today. I was at a deposition this morning run by our lawyers. I'm not an attorney, so I was attending as in my capacity as president of Judicial Watch. And there was a new deposition today in the Clinton email matter, and this was of Clinton State Department IT official John Bentel, who's now retired. He took the Fifth Amendment. We've had, again, a new State Department official who had worked on the Clinton emails, it looks like, take the Fifth Amendment in response to Judicial Watch's questions. And now we've been given the ability to take discovery by Judge Emmett Sullivan in one of our Freedom of Information Act cases. And by my count, Mr. Bentel took the Fifth Amendment over 90 times in response to our questions. And this is what he exactly said. He said, on advice from my legal counsel, I decline to answer the question and I invoke my Fifth Amendment rights. Again, 90 plus times. And even on top of that, his lawyers and lawyers for the Justice Department objected to some questions as being outside the scope of our discovery. And they directed Mr. Bentel not to answer them at all, so he didn't even invoke his Fifth Amendment. He didn't answer them all. And what was interesting is we'd asked questions about whether Hillary Clinton was paying his legal fees, offered him employment, or other financial incentives. And there were 3 government attorneys there and 2 personal attorneys. So Mr. Bentel had 5 attorneys there at the law firm where this deposition took place this morning. Why is it we wanted to question Mr. Bentel? Well, here's the ruling from the court granting our request. The court is persuaded that Mr. Bentel should be deposed because the record of this case appears to contradict his sworn testimony before the House Select Benghazi Committee. Specifically, Bentel testified he was not aware that Clinton's email account was housed on a private server until media reports in 2015. However, several emails indicate Bentel knew about the private server as early as 2009. Of course, we attempted to ask him about those emails, and that's where he took the Fifth, in addition to every other question we asked. In addition, Bentel told employees in his office that Secretary Clinton's email arrangement had been approved by the State Department's legal staff and also instructed his subordinates not to discuss the Secretary's email again. So people came to him with concerns, and he basically told them to be quiet. And he didn't want to answer questions about that, citing his Fifth Amendment rights. So this is the second witness in this case that's taken the Fifth Amendment. I think there have been additional witnesses in the House that have taken the Fifth Amendment. You may recall Brian Pagliano, Hillary Clinton's IT official, who was really working directly on the system, took the Fifth. So now we've had 2 witnesses out of the 8th or 9th person we've deposed, taking the Fifth Amendment in this case. And I tell you, this highlights the disturbing implication, as I say in our release, that criminal acts took place related to the Clinton email and our Freedom of Information Act requests. You know, my understanding is you can't take the Fifth unless there's a reasonable fear of criminal prosecution. So evidently this witness has a reasonable fear of criminal prosecution something related to the Clinton email scandal, and we can't even get FOIA questions answered as a result. So this is just an extraordinary situation and highlights the grave nature of the Hillary Clinton email scandal. And why is it that Hillary Clinton wanted to hide these emails? Because they were something that she didn't want you to see, and she deleted emails, including, now we found out, thanks to Judicial Watch's litigation last week, classified emails. And at least one classified email was recovered and turned over on Friday by the State Department to Judicial Watch. It was posted on the State Department's website, so you can read that. But secondly, we have separate groups of emails coming to Judicial Watch that show that her testimony, even recently to Judicial Watch, should be questioned. For instance, she testified that she couldn't recall any communications with Brian Pagliano about her email system and how the system was managed, how her emails were managed. Yet we have emails, again, these are emails that Mrs. Clinton didn't want you to see but were recovered by the FBI, that show that she was communicating with Pagliano about her emails. She was getting text messages from Pagliano, and the emails show that she was communicating repeatedly with him about problems that she was having. Again, this is the message from Mrs. Clinton to Brian Pagliano. Help! Once again, I'm having BB trouble, Blackberry trouble. I'm not receiving emails, although people are getting ones I send, but I get their replies on my iPad. I've taken out the battery and done what I know to do, but with no luck. Any ideas? This same person said she had no memory, could not recall any communications with Brian Pagliano. Obviously, that really doesn't withstand much scrutiny, and I don't know what else to say in terms of information again suggesting the First Lady or Mrs. Clinton wasn't being truthful when she told us she couldn't remember these things. And again, she also couldn't remember knowing anything about the Clinton email scandal, her security issues related to the Clinton email scandal. And, but again, we have new documents showing communications with General Petraeus where Mrs. Clinton talks about her Blackberry blues. I didn't write that, Mrs. Clinton did. And this is specific emails that she sent to Petraeus that involves her email and security issues. David, sorry to be so tardy in responding. I've had Blackberry blues. I can't use mine all day long since my whole office is a SCIF, which is short for Sensitive Compartmented Information Facility. You're not allowed to use any non-secure electronic devices in a SCIF. I don't yet have a computer, and I've had to change my email, my address, and lost some of my traffic. Now, the State Department told us she didn't have a computer, so it's interesting to see that she talks about getting one potentially. And the discussion she's having with Petraeus is about a sensitive personnel matter, so sensitive they didn't want to tell us what it was about. And she tells Petraeus that you should need to communicate with me by my personal email account. Now, Petraeus at the time was head of CENTCOM and the United States Central Command. Why would you tell a general to send national defense information potentially to your personal email account? Wouldn't you say, hey, wait till I get my official State Department email and then send me material that you need for me to see? Again, she pretends not to remember these types of discussions in her testimony. So we're going to have to figure out how we alert to the court to these discrepancies and what we do next with the testimony that we received from her. Recall, she responded under oath to Judicial Watch in our discovery written form to our 25 questions. So when I say her testimony, I mean her answers to the questions. So lots of Clinton email news. Another official taking the Fifth Amendment related to the Clinton email scandal. We've got new Clinton emails that suggest that she wasn't being truthful when she testified to the court in this case just recently, and emails that raise, again, more questions about her mishandling of classified information. And this is why the Clinton email scandal isn't going away and won't go away no matter what happens in November. Now, speaking of what happens in November, as you may know, Judicial Watch has this major initiative called our Election Integrity Project. We don't believe the elections are as clean and as fair and as free from fraud as they should be. And we've taken litigation steps to ensure that the rolls are more clean. We've defended voter ID and done all sorts of important work, very lonely work in the sense that only few of us on the conservative side of the aisle takes this issue very seriously or is able to do much work here. So we focused on Virginia and announcing today that we will have volunteer poll observers monitor polling sites in Virginia on Election Day. So your Judicial Watch is going to try to ensure the integrity of the elections in at least one key state, Virginia. And why Virginia? Lots of negative information about election integrity in Virginia that makes it worth monitoring. We've got 1,000 aliens or residents who aren't U.S. citizens who are on the voting rolls in 8 Virginia counties. And that means if you extrapolate it, you probably had about 6,500 non-citizens are currently registered to vote in Virginia. And a September 2016 report by our friends at the Public Interest Legal Foundation found that only 8 jurisdictions out of 133, by the way, found that 31 non-citizens had cast a total of 186 votes between 2005 and 2015. And the most alien votes were cast most recently in 2015, were cast, in 2012, followed by 2008, both which were presidential election years. And there, of course, a total of 133 jurisdictions. So in 8 of them, you had 186 illegal votes from illegal aliens, So this is a mere fraction of the total potential legal votes. This is why we need to be monitoring polls in Virginia. Also, we have reports of deceased voters on the registration rolls, and we found there's a recent analysis using a Crosscheck program, which allows states to collaborate to make sure that people are registered in more than one state. There were 57,923,000 Virginia voters, according to a 2013 report, that were registered in more than one state. And by the way, this analysis that looks at only 23 states. It doesn't include states like New York, California, and Texas, which are the most populous. And it's probably even worse. This is why you need Judicial Watch using the law to allow our volunteer polling monitors to go and look at select polling sites and to expose and deter any voting fraud. And this project is being run by Bob Popper, our Judicial Watch attorney who runs our election integrity project. He was the deputy chief at the voting section in the U.S. Department of Justice and had been a veteran poll observer for the Department of Justice. So he knows how this is done. And we're not going to be there to intrude upon the process. We are going to be neutral. Our observers are going to be silent. And we don't oppose or endorse candidates for public office. So we're not going to be there in favor of any candidate. And we won't be there of any defending or supporting or opposing any party. We'll be there on behalf of Judicial Watch's interest, purely public interest in making sure that the voting in Virginia, as best as we're able, given our capacities, is free and fair. So a lot of Americans are concerned about voter fraud. We are too, and that's why we're taking steps, at least in one key state, to make sure that those who want to commit fraud should be worried about at least one neutral, independent observer perhaps catching them, and that is Judicial Watch. So a lot going on. Keep track of our work, obviously, here on Facebook and on our website at judicialwatch.org. And I tell you, those of you who are supporting us, please continue to support us. If you're not supporting us, you can see why Judicial Watch is where it's at when it comes to exposing, combating effectively government corruption. No one else is in court the way we are about the Clinton email scandal, still putting people under oath, getting questions under oath from Mrs. Clinton answered, and still pursuing this. And of course, we're on the front lines on the election integrity fight. And you can trust us, but you can't trust the political parties or the candidates to tell you the truth about this. We're here on behalf of you, the American people. So keep up the support, and again, join our cause if you haven't already. Thanks for joining us today with this longish but important Facebook Live event. And I encourage you to share this important information with your friends and family on Facebook, on Twitter, and elsewhere, and get the word out about this essential work to protect our country's respect for the rule of law. Thanks again.